Recreational use of marijuana is now legal as of today here in Connecticut.
And Fox 61's Keith McGilvery is live for us in Hartford with an attorney answering a lot of questions that people might have. What can and can't you do now? Keith?
That's right, Eric and Tim. Andrew Glassman, Pullman, and Connolly, we appreciate your time this morning. We are talking about legalized recreational marijuana here in Connecticut, and it is a talk. I want to jump into these questions that we're getting from viewers at home. So the first one comes from a gentleman, Jose Cruz. He says, hello, I have a question about legalization of weed and CT. How will legalization impact drug testing for employment purposes here in Connecticut? What can we tell Jose at this point?
Well, it really won't. We're still going to have the same protocol. We're going to have the one issue you can't address is you can't base it on smell. It's specific in the statute that you have to go through a testing protocol. And traces of THC in the blood will not result in, or can't result in, an adverse employment result for these employees. But we have the practical issues. We have, how does that employee look? How do they act? Are they doing their job? Is there a reasonable suspicion that they may be under the influence of something? And in any case, an employer has the right to then further assess, require a urinalysis or additional testing, and judge from that whether that employee was intoxicated in the workforce.
I want to get right to the next one if we can. It comes our way from a woman named Sue Lowe, and she says some of what Jose said, but I'll read her whole question. How will impaired driving be tested, dealt with, and can you now come to work alcohol impaired as well as high? How will that be regulated? And you touched upon this a little bit already, but what do you say to Sue?
Well, you can't come to work under the influence, period. An employer has the same rights they had before. So they're going to assess objectively as objectively as they can to determine whether that person should be taken off the floor, if on a factory floor, taken out of the system, and further evaluated on behalf of the employer to see if that person should not be in the workforce, should not be on the floor, and should seek assistance in some other way.
We know that folks will be allowed to have 1.5 ounces on them, up to 5 ounces in their house or car. Are there things in this conversation that still needed to be sorted out? As an attorney, do you feel pretty good moving forward? Are there questions we still have to answer?
There's always, this is an imperfect system, just as any other evaluation of individuals using an intoxicant might require additional evaluation. So we have law enforcement issues, we have employment issues, and my primary focus is on helping businesses get licensure, set up businesses, and put a business plan together, raise investment funds, all of that. But out of necessity, we've learned all about the statute, but there's a lot of imperfection in this statute, and it's going to take a while for it all to shake out. We don't have regulations yet. The DCP is very good at identifying its regulatory protocol, and it will in this case as well. We have the model of the medical marijuana statute and the regulations associated there, and those will be applied in this case and further expanded. But we have some time to develop those regulations, and hopefully the public will have some input into that process.
Andrew Glassman with Pullman and Connolly, thank you for walking us through all of this. We know that you have a lot of questions at home. Our digital team has put some of the most popular Q&As from this discussion, from this new legislation, right up on our website, fox61.com. If you have questions about this moving forward, send them our way. Our thanks to Sue and Jose at Share61 at fox61.com. We'll continue to answer as many of those as we can. In Hartford this morning, Keith McGilvery, Fox 61 News. Tim and Erica, back to you guys.